I think we're running.
Awesome. Hello, everyone. Again, my name is Ashley. I definitely would want to invite you guys that if you have questions anytime, feel free to ask your question while it comes up, or feel free to ask it, and there will be a question and answer session at the end of it. But we would greatly invite you to ask questions whenever they arise. They kind of help us guide the conversation, and so we can provide better information to all you guys. First thing I think that I will start on, so everyone in here is at least aware of what divorce is, right? Marriage and divorce. Marriage, of course, is when two people come together and create this legal union amongst themselves. Divorce is on the other end of that. That it's more of the complicated end, I like to say. It's when when the legal system recognizes you as a couple and you want to separate that and no longer be considered this marital union any longer. Divorce in Idaho is not so complicated because the court system does a really good job allowing individuals to be able to do their own court cases or divorce cases here, especially in Ada County. Are we mostly in Ada County, or are we kind of all over Ada County? One thing I'd really like to stress to you all is that Ada County Court Assistance Office, and it doesn't matter really where you're located in the state, but if you can just Google Ada County Court Assistance Office, it will bring you up to a really great website that has a bunch of forms on it. So you can go on there and go through family law or small claims or, goodness, what else do they have?
There are some
landlord-tenant issues, everything else. And I know Leslie will probably touch base. They have some forms available on their website also, but I always like to touch base because at least if you know what forms to expect, it kind of guides you a lot easier through the process, and then you can. They do a really good job with the forms. It's more of a plug and chug type of thing, which is really nice that they've kind of set up for people to be empowered and do things themselves, which I think is exactly what this group is gathered here today to help do as well. So reverting back is, in Idaho, when two people decide, or even one person wants to decide to get divorced, it does take just one person needing the decision to move forward. That's an often question we get. It does not, both people don't have to agree to get divorced. Just one person can file. It doesn't really matter who files. A lot of people, because there's a petitioner and a respondent in the action. It doesn't matter who's the petitioner, who's the respondent. Some people get caught up thinking, well, I have to file first, so I'm, the petitioner. It doesn't matter. The court doesn't recognize it being any significance to it.
Does that mean that the petitioner doesn't have like a higher burden or anything like you would in other civil matters to prove something?
It depends, because when an individual files, so it kind of goes into the filing of it. So when one person files, the initial person is called the petitioner. They're the one that files the petition to start everything. That individual put their request in the court document into the petition, and then the respondent has an opportunity to respond to those documents. So the petitioner does, so to say, have a burden or needs to prove what they want in their petition. So in the petition, the petitioner is basically asking the court to award them something. So in a divorce, it could be a vehicle, a house, the children, the dog. So the petitioner is basically asking the court in the petition to give them those certain items. Likewise, the respondent also has the same opportunity. So they'll also respond to the petitioner's allegations and then also lay out their own response or their own request to the court. So each party eventually will have to, I guess, have their own little burden. But again, each party has an opportunity to respond to each other. So long as the individual knows that there's no race to the gun to try to file first, I think that's probably the basic outline of that. But so in Idaho, I hope that answered your question. It will probably become more answered in a little bit too. But in divorce, or in Idaho, there's several grounds for divorce, they call them. Many of you probably have heard where in some places there has to be a party who's at fault. In Idaho, there's a no fault rule, meaning that, and they call it irreconcilable differences. That just means two people don't get along anymore. In other states, they sometimes have like a 6-month wait period. So you can file, but you have to wait 6 months before you even get a court to look at you. In Idaho, they recognize that you don't have to do that. Adult people can make their own decisions, and when it's time to, part ways, they should be able to do so within a reasonable amount of time. So with that, there's several different grounds, but the most common is irreconcilable differences, which means you just don't get along anymore. But there's also adultery, cruelty, habitual intemperance, and a couple other ones along with that. When one starts the divorce proceeding, again, if you guys inform someone to go get the forms down the Ada County Courthouse, the court assistant's office, they will go down to the courthouse and they'll get a really nice packet of information. It depends whether there's children involved or there's not children involved. Because if there's children involved, you have to go through child custody and so on and so forth. So they're going to have an option of these two forms. I'm just going to talk about the child custody one because that kind of addresses it all. So they come back to you with these forms, set of documents, and it really is like a plug and chug format. You kind of fill in things as you go. It'll ask you where people live, if there's children involved, what their assets are, so their cars, their house, their sneakers, really whatever you want to put on there. It also asks for debts, etc. Another important piece to it is it asks what the petitioner, the first person filing, wants to do with the children. And that's generally, I always joke that family law practitioners deal with people's two highest values, their children and their money. And so it can get interesting, but so long as people are aware of what they have and what their rights are, it tends to be a lot easier. But with this petition, then they put down what they want, and Ada County also has a really nice, it's called a parenting plan. I think Leslie was going to talk a little bit about the context of that, but it's basically something that you put with the petition or the response that helps you lie out what you want for child custody, what you're asking the court to order you for child custody, so how the two parents are going to share the children. In Idaho, are you talking about child custody part of it? Okay, so I'll wait on that also. So once you have this petition, and then you're going to also have that parenting plan along with it, and then you also are going to be given a summons. The summons is something that the clerk, you'll take back to the courthouse when you go file your documents, and the clerk will go ahead and take care of that, stamp it, and that is basically a document telling the non-filing party that they are being summoned to court. They're being told that they are now being sued, and their response is requested at court. So what's really important, I like to tell people, is when they take these documents back to the courthouse to file, please tell them to bring multiple copies. I always recommend people bring 4 copies of each document. One, for the original will go to stay at the courthouse. There's going to be a copy for them. There's going to be a copy for the person, the spouse, who's going to be served the documents, and then an extra one. That could be if they decide to retain a counsel later on, if they just, they lose their initial copy and they want another one. But copies are very expensive at the courthouse, and a lot of people, there's better reasons or better things to spend your money on than paying for copies down at the courthouse. So better safe than sorry. So when you go in and you take these documents and take them to the courthouse, the clerk will stamp all the copies, keep the originals, and send these individuals with the petition, the extra copies of the petition, summons, and then there's also going to be a couple documents that are going to be given that are issued by the court themselves. And this is something that a lot of people get nervous about, but they're called joint temporary restraining orders. A lot of people see restraining orders and get really nervous thinking, we think on cops, if someone's going and violating a restraining order against someone. To an extent, yes. But this is an order that's telling these individuals that they can't. There's one for children and there's one for property. One for children basically says you won't take off with the kids, you won't restrict the kids, you won't harm the kids or bring the kids into adult business type thing. And then the other one for property talks about that individuals won't, sell stuff, hide stuff, make changes on insurance policies, kind of basic. They're trying to keep this marital union sound while they're going through this really hard, bumpy first little bit.
How long would
Yeah.
you say we take? And then, is there any money involved?
Yes.
When you pay? Yeah.
Yes, thank you. So when the individual goes down there and files these documents, they will have to pay a filing fee. If it's with children, it's $207, but you can also file for a waiver when you're there at the courthouse. So individuals who are low income or need special assistance, they're able to go file these waivers. You have to file the waiver when you file your documents, but they will consider the waiver before they actually request you to pay anything. So for example, you go down there, bring all your documents, bring your waiver, they'll take it all from you, determine whether or not, it's definitely not immediate. I think takes a little bit of time.
A couple of days, yeah.
And then they'll let you know whether or not you qualified or you didn't. If you didn't, you go back down there and you pay your money and you go on from there. So yes, there is money to file, but otherwise if you're not applying for the waiver, you just go down there, you pay your money to the clerk to get it open, and then it goes from there.
How long it takes to get a hearing, or how long it takes the whole process?
So the whole process, so I think the first little bit is the most confusing for individuals, and that's with the form filling and everything out. But once you get all your forms from the courthouse, you serve it on the party. After, so regarding service, the specifics are available on the Ada County website too, but it's really important that the individual knows they cannot serve the documents on the other party themselves. So if the husband that filed cannot go and give the documents to the wife unless she agrees to accept those documents. Otherwise, it needs to be a third party that's not related to the action that can go do it. And this is another thing that the Ada County Courthouse can also help. You can either go to the sheriff, have a process server, have Uncle Joe go do it, someone who's not related to the action. So once that individual is served then by whoever chooses to serve these documents on them, and they'll be served also with one copy of everything you filed at the courthouse. And again, it's process-wise is available on the website too. But once you serve the individual, then that person has 21 days to respond. So that's a firm timeline right there. There's at least 21 days that the individual who filed is kind of waiting.
Is that 21 days, not counting weekends and holidays?
21 days counting weekends, but if the 21st day lands on a holiday, it's the following day.
Okay.
So then, during this time also, the individual who filed, oh yeah.
Well, what happens if the other person doesn't want to be served and refuses to accept the papers?
That happens a lot, because especially someone who doesn't want to get divorced. At that point in time, at least in our private practice, we hire process servers all the time. So the people in the TV shows you see going out saying you got served, you know. So those people get really creative and they're good. They do cost, I think we pay about $60 a service, which a lot of people don't have to spend. But if that's the only way you can serve them to get it over and going, that generally is probably the best way to go about it. If they won't accept service, they have to accept service no matter what to get any relief from the court. And a lot of people, unfortunately, we also help at a clinic downtown who they haven't been able to find the individual. There are ways around that if you can't find them, but the court doesn't like to look at those. It's like posting on by publication, where you can post it in like a magazine or a newspaper, or even, it's not really well liked, but people will have a social media posting type. That's for the really hard cases, but it's rarely ever approved. So hopefully personal service is the best form of service an individual can do. I hope that answers that question. So during this whole 21-day period, there will also be an order to attend a parent.
A focus on the children.
Yeah, focus on children, but it's like a parent class, a parenting class. I don't know what you consider it.
It's essentially a class where the court hires a social worker to talk to parents who have children involved in their divorce case. And the idea behind that class is to help the parents understand how to keep the children out of the middle of the divorce case, and kind of the best way to approach having conversations with kids. And then there's a period after that class where if the parties get along well, they may be asked to sit and chat about a possible parenting plan going forward that night of that class. So.
And one question I always get asked, do I have to go? Yes, it's mandated by the court, they have to go. Does it cost money? Yes. But yet again, there is a waiver available, and as soon as they have that form demanding that they go to this class, I tell them to contact the courthouse ASAP, because it can take a little while to get a waiver. You don't want to get in trouble for not attending because you didn't have the funds. So then once that's rocking and rolling, then the 21 days come, and let's hope that the other party filed their response telling the court basically what they want. At that point in time, the court generally orders mediation, where the two parties will go, and I don't know if they're not represented by counsel. I think they're still generally required to go to mediation, at least in Ada County. Generally,
Yes.
Unless there's an issue with domestic violence and so on and so forth. That's something probably Leslie will touch base on.
And I do want to note, I don't know if you're aware of this, once you have an order from the court to go to mediation, there's an agency within the Ada County Courthouse called Family Court Services, and they have grant funding available to help reduce the costs of mediation if you are low income. So you can
Okay.
take that order to Family Court Services, and they can help you apply for that grant funding.
So in cases where one spouse, while they have a decent income, doesn't necessarily have access to it because of the way the relationship is, would they be eligible for a waiver potentially, or what would their situation be in trying to pay for those fees?
I believe if that's been, they would want to put that in their response or in their petition, whichever thing they file with the court.
Include it in part of their allegations?
And then I would call Family Court Services still and just explain the situation to them and see if that's going to
How to
work for them
proceed.
or not.
Okay.
Yeah.
And then if those 21 days,
Uh-huh.
the responder doesn't respond, do they default the case or?
Correct, yes, so long as the individual can prove that they're a service made, so that's why it's really important to have that personal service, then yes, then you can ask the court to enter a judgment in the filing party's favor for whatever it said on the petition.
Okay.
Another thing is it's super important to put everything on that petition and make sure it's specific. Especially I don't know what's going on, but there's been a lot of people who are trying to outsmart the other, and we have a lot of people coming into the office. Someone got stuck on a credit card. Well, the credit card was never put on the petition or the judgment, and so the court doesn't know to order anything on that credit card. Well, if it's not ordered in the court, the individuals are stuck with each other on like this credit card. For example, we've started putting in leases and utilities in our petitions. So if two parties are on the same power bill together, that we've been saying that those individuals will be on that power bill until the judgment is entered, and then they have 30 days after the judgment is entered. Someone needs to assume it. Generally, it's whoever's staying in that housing, and it could be husband, wife, whoever. But that person will assume, so take over that power bill to release the other person, especially with power, because you can't generally run two power accounts through Idaho Power at the same time. So that's another sticky situation, because you have, let's say, husband staying there and wife is leaving, but wife is still on that power bill. She can't get another power account in her own name. And that's been a big sticking point we found recently, because then the husband doesn't let her off just to, not be kind about it.
And do they remain jointly responsible, severally and jointly responsible for that power bill?
That's another thing, is that if it doesn't say that they're each having to pay 50% of this power bill, then no, they're not. It's whoever basically gets stuck with it. So we've had people come to us because there's a $380 power bill that no one wants to pay anymore. Well, they're both stuck with this power bill now. Who's going to pay it? It's going to be the person probably who wants to get rid of it the quickest, and then they can figure out how to try to get their money back from the other non-paying party. So if it is not,
Can you remove your name from the power account before, because you are listed on a power account?
that would be, from what I understand, I don't know. There was I thought it was Idaho Power that was really sticky about removing people without authorization from whoever the other person on the account. And I don't recall if it was Idaho Power, but that goes to that, so that it sticks these people into this account now. And if it's been pretty silly, because we've had to have the court help us in a lot of ways, and some of it was been utilities to force these people to, because you think everyone's getting along well, or someone's just going to assume it or whatever else, but there's all these little intricate things that go on. So I guess the moral of that part of it is that if there's credit cards, make them write credit cards, who they're to, who's paying the balance, when they're supposed to pay the balance off by. Same goes for the utilities, leases, because if the one person gets in default in a lease and they're both on the lease, that can greatly affect them from getting public housing in the future, any type of grants or assistance or whatever. And so that's really important for that part of it. And it also, you want to put under the petition, like who gets what item. That's another issue we've seen a lot of. Let's say husband stayed in the house, wife left all of her stuff there because she couldn't take it at that time. If, let's say her grandmother's necklace, if that's not on that judgment, the judge doesn't know to order it, therefore wife doesn't get grandma's necklace. So it's really important. We've been telling people to put anything of value to them, even though a lot of the court forms say over $100, we're telling everyone to put everything that they want back in specific. So don't say grandpa's books, because the court doesn't know what grandpa's books are. You know, say 1980 Gulliver's Travels, you know, something like that on it, because unfortunately we're having to be very specific to allow the court to help us enforce these judgments. And so back to one question that we had is kind of the timeline of things and having, so after this whole situation when everything's filed and everything, then mediation occurs. Mediation, I don't know if you guys know what that is, but it's when the two parties come together and they basically sit around a round table with a neutral party. It's just someone who's not related to the situation. It's helping these people try to come to an agreement, then which they can reduce to writing, so put it down, and then give it to the court as a final agreement. So after the mediation, you pretty much know if you're going to have to go up for hearing or not. Once you, and mediation also can be several sessions. I always tell people you don't have to agree to everything the first time. That's very important because a lot of people go in there thinking, oh my goodness, if I don't agree to everything that they want, then this is just, we're going to go to trial. And that's not true. You can go to mediation as many times as you want to, so long as it's productive. So one individual, yeah?
I have a question. If I open up the credit card or something without my husband, you know, I can do that. I can open up my own bank account, my own credit card. Is my husband is going to be still responsible if we get divorced?
Possibly. The reason why I say that is because it probably depends on the terms you open it up, because it goes into, and I think this is Leslie, or maybe something we'll talk about, but the court would look at what you used. So let's say there's a $1,000 balance on that card. What did you use that balance for? So in Idaho there's different types of property, and this is how it kind of gets divided. Is there's community property. It's everything that's acquired during the marriage. So let's say we bought a car together. That car is community property. But there's also separate property. This is property that you acquired before the marriage or during the marriage that was from an outside source that was only directed to you, so like inheritance. So let's say you acquired that $1,000 credit card bill and you bought a new couch set for your house with it. So that you bought something for the community. So now the judge is going to look at it and say, even though that's your $1,000 card, it could be both parties need to pay into it because you both are using this couch set, and also who's getting it at the end. Let's say you bought it, but you're taking it, then you're probably going to be stuck with the debt. But if you bought it, and he's taking half and you're taking half, then you're probably going to 50-50 it. Or you can also use that to barter in mediation. You know, you get the couch set, but he take the debt because you're taking debt of something else. So on and so forth. But
likewise, if I open my own account and I put my paycheck into it while I'm still married, that money still belongs to the entire marital group, the community, right? Even though I earned all that money and it was in my account, it still belonged to the whole group regardless.
correct. Yep. So that's it's called community income. So anything that is also, like I mentioned, acquired during the marriage, so clothes, furniture, whatever else, also the income. So let's say you guys are both working, throwing money into either a joint account or a separate account. Anything within that account is technically something that it's the community's asset. So let's say one individual, this is really likely in a stay-at-home parent aspect. So let's say wife is the moneymaker and goes out and makes, $2,000 a month. That money gets dropped in. Well, husband also has a right to some of that money at the end because husband was still doing something for the community. Husband was one staying home with the children, for example. So that, technically, whatever's in that bank account, so long as it was acquired during marriage, both parties are entitled to some of it, half of it, depends, but that's the general rule to that. So in divorce, there's the property side of things, but then I also mentioned that on the petitions, there's either deals with children or non-children. So with the children side of things, it gets a little stickier. As I mentioned, the two best assets or biggest assets to people are their children and their money. So I'd be happy to answer more questions about this point, but I think I'm going to pass to Leslie to talk a little bit about the kids portion of it, and then we can kind of round table and go that way.
Sure. So in Idaho, I'm going to start with kind of some baselines of Idaho law about children, because once we get to the point of filing a custody suit, it's very similar to what Ashley described. So just to start off with, in Idaho, both biological parents have equal parenting rights to their children until a court of law decides otherwise. So, for example, in a marriage, any children born during the time of that marriage are considered the biological children of the husband, or the legal children of the husband, depending on if there's some kind of contest about biological paternity. If the children are not conceived during a marriage, but there's either an affidavit filed with vital statistics where the father swears under oath that he's the father and then files that, or if his name is put on the birth certificate, or if the biological mother is acknowledging that he's the father of the child, those are all ways that entitle him to equal parenting rights to that child. However, if that affidavit isn't filed, if he's not named on the birth certificate, and if the mother is refusing to acknowledge him, then he doesn't have any legal rights until there's a paternity action brought from the court.
So, how about if you are not on birth certificate? Because when the child born, they put on birth certificate, and then there's a birth certificate issued, and then later on you apply, they have another birth certificate with your name on it. Which one is going to count?
I think in both of those examples you said the name is on the birth certificate.
No, the first one, the mother, the dad is not there.
Okay.
So they don't put him, they don't have his information. They don't put him on the phone.
Right.
And then after a month, they send the birth certificate without dad. It's unknown. They don't know the dad.
I'm still not sure I'm following you. I'm sorry, Eve.
Do you mean like dad is known and he's not on it, and then dad is unknown completely?
He's not on it, but they know who he is.
Okay.
But he's not on the birth certificate.
He still would have to bring a paternity action.
But if you later on, he end up on the birth certificate.
Oh.
So which one is going to count? Because you have a
She
two.
acknowledged it later.
Yeah, you have a two birth certificate now.
Oh.
Which one?
Later one, right?
It would probably be the later one. Yeah.
Okay.
That would definitely be a point of proof during the custody suit. If she were contesting the validity of the second birth certificate, for example, like if she said that's fraudulent or it's not real, then that would be an issue the court would have to decide.
Okay.
But I will often, if the parties aren't married and they're wanting to deal with custody of their children, I'll often file a paternity action. And generally, we'll just acknowledge that the person is the legal father and just keep going with it. But sometimes, maybe I have a client that doesn't want to acknowledge the father, and then it's on him to prove that he's the father at that point. Yeah. So when Idaho decides, when you decide you're going to involve the court, so let's say you've got parties who either never were married or parties who were getting a divorce, and now you've got these kids and you've got to decide what you're going to do with them. That's what we call child custody. We're going to make a child custody determination. And in Idaho, there's physical custody and there's legal custody. So physical custody is where the child spends the night. Legal custody is generally considered decision-making power. So does the child have special needs? And if so, how do you treat those? Does the child have special educational needs? And if so, where does the child go to school? What kinds of interventions do you have? Those are the types of decisions that fall under legal custody. In Idaho, we have a presumption or an assumption that joint custody is going to be in the best interest of children. So Idaho says, you know, we understand that parents don't always get along forever, but we do expect parents to keep parenting their children together in general. So joint custody does not necessarily mean absolute equal time between the parents, but it means frequent and continuing contact. And so that can mean maybe one parent has the child every night through the week, but maybe they go over to the other parent's house for dinner a couple of times a week, and then maybe they spend weekends or every other weekend with the other parent. I've had some clients who do like a 3-night schedule, so they'll have their kid for 3 nights, then the other parent has the kid for 4 nights, and then they switch so that they've got, like the original parent has 4 nights and the next parent has 3 nights. So there are a number of ways to determine where the child stays and how often they stay there. Joint custody does assume that the parents are going to be able to work together to make decisions about education, medical issues. Sometimes the court will get us involved as extracurricular activities, but oftentimes they don't really want to give that much control over a child's upbringing to either party. So even though joint custody is the assumption in Idaho, there is also the opportunity for sole custody in Idaho. Sole custody also rarely means that one party is going to have all of the physical custody of a child. Even when you have a sole custody situation, oftentimes the other parent who's not the custodian will have visitation, is what we call it, with the children. But sole custody also gives one person all of the decision-making power over the child. To get sole custody in Idaho, you usually have to prove either that there was domestic violence from one party to the other, or you may have to show that the child has a bunch of complex educational or medical needs and that one party is just better positioned to make all of those decisions on their own. So it's a much harder thing to get in where sole custody is. To decide where a child goes, so to decide joint custody, both physical and legal custody, the court looks at a number of factors when they're trying to decide what's in the best interest of a child. And they will take into consideration the wishes of the child. So if the children are old enough to voice an opinion to the court, there are ways to get that opinion to the court. They'll consider what the child wants. They will look at both of the parties' own wishes. So they'll look at the petition that one parent filed and they'll say, okay, what was their suggestion for custody? Then they look at the other parent and say, okay, what was their suggestion? And they'll see if they think one of those things is better or worse for the children. They look at the relationship that the child has with each of the parents and with any siblings. And in Idaho, that will often mean siblings, not just of the couple trying to separate, but also if either party has children from another relationship and the children have a good relationship with those siblings, the court often tries to preserve that relationship. They consider that very important to the upbringing of a child. They will look at the way the child has adjusted to its home, its school, its other community members. So they're going to want to look at how long has a child been in a certain school system. If we changed who the child lived with, would that uproot them from, church friends that they have or daycare friends that they have? Is it going to uproot them from their school? Are they going to have all new teachers? That's another thing they're going to look at when they're deciding where a child needs to reside after the parties separate. They're going to look at the character and circumstances, is what they call it, of the individuals involved. Usually that ends up meaning, is there a criminal history for one or both parties? If so, what's the nature of those crimes? Are we talking about a lot of speeding tickets? Are we talking about substance or alcohol abuse? Are we talking about violent crimes? And they're going to consider, if the parties have things like that on their record, they're going to consider, okay, who's going to be a positive role model for the child given some of these other issues in the parties' lives. They look at another factor that's called the need to promote continuity and stability in the life of the child. And the way I've often seen that interpreted is, who gets these kids to school? Whose responsibility has that been while the parties were together? Who was making sure the children got meals? Who made sure they got to bed at decent times? Who was getting them to extracurricular activities? Those are the types of things that the court looks at Because if one parent has been taking on that burden while they were together and then they separate, the court's going to assume that that parent is probably still best positioned to continue helping those things happen for those children. And then the last factor they look at is domestic violence, which is the thing that I was called in here to talk about most primarily. And they define domestic violence for purposes of child custody as the physical injury, sexual abuse, forced imprisonment, or the threat thereof of a family or household member. So I'll break that down a little bit. So physical injury doesn't necessarily have to mean something that you've got a photograph of. So certainly if you've been injured by a partner and you have, scratches or bruises, that would be considered a physical injury. But often if you have a party testifying to the court that you've been in altercations before, that they've, held you, kicked you, those types of things can count as a physical injury. Sexual abuse in Idaho can mean forced sexual contact. It can also mean things like, using the phone to text sexually inappropriate things to your partner, or it can mean touching them in ways that they didn't want to be touched. Sexual abuse is a lot harder to prove in Idaho, but it's definitely among the things you can tell the court if you feel like the other parent is not healthy for the child. Forced imprisonment is one that I don't know that we really talk about very often. It's not as intuitive, but forced imprisonment basically means cutting off the liberty of one partner. So that often means their bodily autonomy. So if you have a domestic violence situation and one of the parties tries to get out of that situation and the more abusive partner literally locks them in a room or blocks the doorway with their body or pins the person in a corner, that's something that can mean forced imprisonment. And so I often, all I do at Idaho Legal Aid is domestic violence family law, and so we will often go through all of those definitions to figure out what all we need to present to the court as evidence of the domestic violence. Domestic violence itself, since I've been asked to talk about that, is contemplated differently in society than it is by the law. So there's what we call an advocacy definition, and that is the definition that people at domestic violence shelters would use to define domestic violence, but the law doesn't necessarily define it in the same way. So I've talked a little bit about how the law defines it for purposes of custody, but now I'm going to talk just a little bit about the advocacy definition, because even if somebody has not been physically abused, sexually abused, or held captive by a partner, oftentimes there are other forms of abuse that might still warrant seeking services. So none of this is in the law, but these are other tactics that we see happen a lot in the domestic violence field. So things like financial abuse. Oh yeah.
So how do you prove that somebody has been under forced imprisonment?
Oftentimes you have to just testify about that. So that's getting a little bit more complex in terms of Idaho case law. Technically, according to case law, if the court finds like a sworn statement to be credible, they can use that as evidence of forced imprisonment. If somebody gets to trial and they testify about an incident of forced imprisonment on the stand and the judge believes that testimony, they can find that to be a credible piece of evidence for forced imprisonment. Or if there is a protection order, and we'll talk about protection orders briefly in a moment, if there's a protection order where forced imprisonment was one of the reasons they got the protection order, they can take that protection order as evidence of forced imprisonment as well. What I do often see though is the court generally wants to either see something like a protection order or they want to see some kind of involvement from the criminal system, because when you're alleging domestic violence and you're asking, for example, for sole custody as a result of that domestic violence, the court really does recognize that if they are seriously curtailing somebody's ability to parent their children, they take that very seriously, and so they really do want as strong evidence as they possibly can get before they go ahead and make that decision. Is that
one thing I'd add to that I tell all of my clients is document everything.
Mhm.
And this goes to kind of how do you prove that. I tell people if it's frequent contact or frequent remarks or frequent things that are going on, get a journal, start journaling stuff that's happening, because all of this stuff can help the individual either remember things that happen, because a lot of domestic violence individuals, they filter things and they don't want to remember things. But if they journal it, they can remember it in the future if need be, and take pictures of everything. So if you have a camera happened to be on videotape during the altercation, keep that. Another thing is I always tell people is to email it to a third party, not involved, even if it's a separate email account that you set up for yourself, just to hold this evidence, because more times than not, I've had people come and say, so-and-so deleted it, so-and-so burned my journal, so-and-so, because this is something that they don't want out there. So if they can get it to a third party server that this person doesn't know about, have at it, burn this journal, because I have pictures of what I wrote.
Yeah, that's really good advice. So in terms of domestic violence itself as a phenomenon, what advocates have found over 40 or more years of studying and talking to people who've been in this dynamic is domestic violence is really a relationship where one partner is exerting power and control over the other partner. And so I was talking earlier about financial abuse. That can take the form of not letting a partner work, so they don't have a way to make their own money. It can look like cutting off access to funds, so taking away a debit card or not giving them access to an account, right? So they don't make joint accounts. Maybe they keep all of their money in one account whose name doesn't have the partner's name on it, right? It can mean demanding that the person give them the money they do earn. So maybe the partner has a job, but maybe the abusive partner is saying, okay, give me your paycheck or give me your cash. You know, I'm gonna take all of this and then I'm gonna dole it back out to you, maybe in the form of an allowance. I've seen abusive partners, you know, ask for favors before they'll give their partner money. So that's one form of financial abuse. I've also seen people who've had their partners keep income secret. So maybe the abusive partner has access to rental income and they're not telling the other partner about this. And so the other partner is living under the assumption that their financial situation is one thing when actually the abusive partner has access to a lot more money and therefore a lot more power out in the community. Domestic violence can take the form of emotional abuse. So putting a partner down, calling them names, making the partner feel bad about themselves, something that we call crazy making. So often I'll see an abuser call the person a name, and the person will be understandably upset, and the abuser will be like, what, it was just a joke, or no, I didn't say that, you must have imagined it. You know, that's kind of the format that crazy making can take. Humiliation is a form of emotional abuse, guilt trips. I see a lot of intimidation. So even if I have a client who hasn't ever reached the point of being physically or sexually abused, maybe the partner has, you know, glared at them a lot, kind of in warning, like, hey, if you don't shape up, you know what's happening next. I see it take the form of smashing things, like breaking walls, destroying the partner's property. Abusing pets is another big indicator that you're in an abusive relationship. If you have a partner who's displaying a weapon, even if they don't use the weapon, if they're bringing the weapon out during an argument, or even just kind of keeping it out where you can see it, that can be really intimidating for somebody who's afraid for their physical safety. Isolation is another big tactic that I see used in abusive relationships. So if one partner is controlling who their partner sees, what they do, who they talk to, if they are using jealousy as an excuse to isolate the partner, that's a form of abuse. Limiting the partner's access to outside involvement. So, no, I don't want you to go to that church group. No, I don't want you to join that book club. Those are all forms of isolation that I see take place in abusive relationships. When you've got abuse going from a man to a woman, so the dynamics that I'm talking about are generally gender neutral. So even if you're in a same-sex relationship, you've got one partner doing these things I'm talking about, that partner is probably an abusive partner. The only place that that's going to be different is when you have a male abuser to a female victim, and they will use male privilege oftentimes. So, I'm the man of this house, I get to decide what happens. Or, you're the woman, it's your job to stay home and do these types of things, and that's why you can't go out. So sometimes when you've got a relationship between men and women, they'll use that male privilege as an abuse tactic. But you don't see that often in like same-sex relationships. It's a different type of dynamic. They will often use children. So maybe the abusive partner insists on the victim disciplining in a certain way that the victim disagrees with, or they'll make the victim feel guilty because she or he won't do what they told them to with the kids. I see a lot of people threaten to take the children away. If you don't do what I tell you to, I'm going to take the kids and move out of state, or I'm going to leave the country, or I'm going to, just disappear with these children. And then the last one that I see, again, and none of these are defined in like statutes, right? They're not codified, but one of the last ones that I see happen a lot in abusive relationships is minimizing the abuse. So, oh, yeah, I pushed you, but I didn't push you that hard. Or, yeah, I called you a name, but you're making too big a deal out of it. It wasn't that big a deal, it was just a joke, you need to calm down. Or blaming the partner for the abuse itself. Well, if you weren't so crazy, I wouldn't have had to do that to you. If you weren't so angry all the time, I wouldn't have had to do this to you. And so that's another way that you can kind of tell if somebody's in an abusive dynamic. So that's kind of domestic violence outside just the physical abuse, because I see this happening rarely. Sometimes you have a couple who doesn't know how to manage conflict, so maybe things get physical, but if you don't have all of these other dynamics, it's not necessarily going to be domestic violence, if that makes any sense. Like, it might just be two people with really poor conflict management skills. So that's why I go through the rest of those definitions, is so as you're working with people, you can kind of get a sense for where the power issues are in a relationship. How much time do we have?
Kind of whatever you want to make of it.
Okay, because I came prepared to talk briefly about protection orders, but if we just want to keep it at custody tonight, we can, or I can go a little bit into protection orders.
Why don't you do a little on protection orders?
Okay, so in Idaho, there are two actions for protection. There is the domestic violence protection order and the stalking and harassment protection order. So the domestic violence protection order, we've talked about the way they define domestic violence: physical injury, sexual abuse, forced imprisonment, or the threat thereof of a family or household member. In Idaho, a family or household member is somebody that you have either been married to or formerly married to, dating or formerly dating. If you have a child in common with that person, they are automatically